Hello and welcome to week 7 of Property B. Is it week 7? Topic 7. Week 6? Anyway, today we will be looking at what is really the most important topic in Property B, the exceptions to indefeasibility, the fraud exceptions. Before we get into that, let's just have a quick disclaimer for academic misconduct. Please try and be as honest as possible in everything that you do, and do not cheat in any material way. But without further ado, it's a very long topic today, so I'm going to try and hurry along because I'm hoping to really go through in a lot of detail I'm hoping to go through some of the cases. I'm thinking today I'm going to put a big emphasis on just kind of really stepping through all the details and the kind of factual matrices around the case law. So I'm just going to get right into it. But anyway, right? So the Torrent system is, as we've discussed last week when we looked at Breskvar, is a system of title by registration, wherein once the instrument is registered, it attracts immediate indefeasibility, despite any invalidity in the transfer process, unless an exception applies. So here, with the Section 42 TLA exception for fraud, the new registered proprietor might argue that they have acquired an indefeasible title and therefore take their interest free from any encumbrance and are immune from attack by Y, the previous interest holder. That's just kind of like the starting point when you think about the fraud exception. Like, that's what they're gonna argue, and then Y, the previous holder will argue, oh no, your title is still that, it's indefeasible, but this exception applies, and it's defeasible because of that. But yeah, so I've got on the slide kind of the different things we might look at. So we have stat fraud, which we're going to look at today. You have in personam claims. You have other registered and paramount interests. We mentioned them briefly last week. You have the registrar's power to correct errors, and you have inconsistent legislation, and then you have the volunteer exception. Today, we're going to be focusing on just the first one. It's quite large, and there are a lot of parts to it, so try and keep up with that. And yeah, let's just get into it. So, Section 42. I'm sure we all remember from last week that the registered proprietor of land shall, except in cases of fraud, hold such land subject to such encumbrances as are recorded on the relevant folio of the register, but absolutely free from all other encumbrances whatsoever. So the important part here, obviously, is the except in case of fraud part of the Section 42(1). There is a lack of statutory definition of fraud in the TLA, so what do? Well, we look at the common law. And Lord Linley in Assets Co., and as refined by the jurisprudence, finds that stat fraud requires actual fraud and requires there to be an element of dishonesty or moral turpitude. Fraud must be brought home to the registered proprietor or to his agents. Fraud must also be operative, meaning that if you fraudulently obtain something which wasn't actually necessary for you to be registered, then it won't affect the indefeasibility of the title. The fraud itself must act to create the transfer or the registration which you are seeking to dispute. And then carelessness will not be sufficient. This will be important later. And then mere knowledge of existence of any trust or blah 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 is not fraud itself. So right off the bat, it's quite a high bar. Think dishonesty and moral turpitude, and you can't just have carelessness. It has to be kind of very, very clear intent on the part of the person, and that's what we need to bring it home to the registered proprietor. So we have the case of Assets Co., where, as I just mentioned here, Lord Linley sets out that you need actual fraud, dishonesty, or of some sort, not constructive or equitable fraud. The fraud which must be proved in order to invalidate the title of a registered purchase of a value must be brought home to the person whose registered title is impeached, or to his agents. We'll talk about agent fraud at the very end of this tutorial. And yeah, it just essentially means that if you're looking at a case and you're trying to figure out, well, has there been some kind of fraud here, you just kind of have to go back to the assets code definition of, is there some kind of dishonesty or moral turpitude? Always just, chuck that. For me, when I was doing the exam, I would always just have, I'd cite assets code and just chuck down, dishonesty in brackets whenever I was talking about fraud, and you'd look at the actions of the parties and you'd determine, okay, are they dishonest, are they not dishonest, and then you'd go from there. The next point is the timing of the fraud. So obviously fraud can occur in many places, right? You could have fraud before the transfer, and in those circumstances, it's actually really not very problematic. So in LoQ, they were a registered proprietor of 322 acres, and they granted a lease over 58 acres to Loke. He then transferred all 322 acres to Port Swettenham, and the agent represented that it would take the whole acreage subject to Liu's interest. This was fraud, as it was intended to be a statement as to present intention as well as undertaking with regard to the future, and that statement was false. So if you make a statement, you tell someone, you induce someone, and you are the proprietor and you have those rights, and you do it with those rights, that is fraud. And that's really not very problematic. Fraud that happens before the transfer is very clearly made out. What is, however, a little bit more complicated is fraud after transfer of title. So Mason and Chief Justice Mason, as he was, and Dawson, minority judgment in Barr v. Nicolay, found that it is possible for the actions of the registered proprietor after registration to constitute fraud if the plaintiff's interest was acknowledged at the time of or in the course of obtaining registration. So this essentially means we have to look at whether there was a relevant interest coming into play when registration occurred. So essentially repudiating is fraudulent. So if you promise to do something and then you're unable to fulfill that promise later on, that will be capable of being fraudulent. It's important to note, however, that in this case, Wilson and Toohey found that only fraud prior to registration was capable of constituting fraud, and decided for Barr's, they decided that on an in personam basis. They still found an exception to indefeasibility and found a way through. However, they found that the fraud must happen beforehand. So what we have here is kind of an unsettled position, and what that means is that in an exam, if you have a similar situation to what happened in Barr, you would cite the minority judgment of Mason and Dawson, and you would note their reasoning, and you would say, well, this repudiation of, clause 4 is problematic, but then you would say, well, the majority or the other finding was that only fraud prior to registration is capable of constituting fraud, but then you would go on to discuss it on an in personam basis. And then, of course, Brennan discussed it on a different basis of common intention. But irrespective of any of that, you would go through these different... This is where Property B is very different to other units, because the law is unsettled, right? And, for whatever reason, they expect us to step it through in the exam and kind of consider, well, what would a court find here if there is no clear principle that we can follow? There is no, it's just apply section 21 or whatever, and just, it is or is not the correct answer. And because of that, you have to go through the different steps. Later, I'm going to walk you guys through the facts of these cases. I'm going to kind of brush through the material, like the basic concepts, quite quickly today, and then I really want to spend a lot of time going through the cases because I think they're really important. But yeah, then we have, so once you've thought about timing of fraud and the nature of the fraud and whether the actions are operative or fraudulent, once you've thought about all of that, then you want to come and think, okay, well, what kind of fraud are we going for here? Is it knowledge of fraud? Is it false attestation? Is it verbal assurance or a fraudulent misrepresentation? So verbal assurance, as we were thinking about in the case of LoQ a moment ago. and then knowledge of fraud, and then false attestation. First of all, verbal assurance. So generally here you'll argue it two ways, and you'll look at it from two perspectives. Either the fraud arises because the defendant had notice and made an assurance in the form of, then you say what the assurance was, and then the plaintiff's interest would be preserved with an intention to destroy the interest prior to registration. Then you cite locu, and then you say this is evidenced by this intention, or whatever. In the case of the defendant would be, well, there was no fraud because it was mere notice of an unregistered interest and it does not constitute fraud. But really, this would purely depend on the nature of the actions and whether they were inherently dishonest or not. And the defendant will argue they did not act fraudulently because when they made the assurance, they genuinely intended to. So this is kind of like where it comes down to your kind of subjective interpretation of the facts. You look at it and you have to kind of determine, well, did the defendant, at the time that they made the assurance or representation by, granting an unregistered lease or something like that, did they think at that time that they would uphold this agreement? But then, later on, they changed their mind. And you can maybe evidence that, there was some genuine intention previously. But, that's always a fun one to try and make out. So briefly, I've got some cases here for you. I'm going to go through these in a little bit more detail later, but for now, we've got plaintiff land sold a portion to locu, but transfer was not in a registrable form. The registered proprietor then decided to sell all the land, including locu's land, but he refused to sell unless the purchaser acknowledged locu's right. So then the purchaser, or the agent of the purchaser, then comes along and he tells locu, no, trust me, I'm going to respect it and blah, 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 blah. And then they purchase it and blah, 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 and then they try and reject, or rather eject locu. The Privy Council here obviously found that a fraudulent assurance was made, and that the registered proprietor had induced him to transfer all the land, and at the time they did not have an intention to evict locu, and they were aware that they could not actually get the transfer without inducing him or without making these representations. So it's kind of important to look at it from that angle. So you want to think, well, what value is there in their false representation? Could have they done it without that? Because, if we look to the first stop point, there was a refusal to sell unless the purchaser acknowledged the rights of locu. So the representation and the acknowledgement that they made was specifically fraudulently designed to undermine the right of the owner. Then we have the case of Bar v. Nicolay, which we've talked about just before, where Bar owned land and operated a general store. He then sold the land to Nicolay and agreed to lease back to Bar, with Nicolay contracting to resell at the end of the lease for $45,000 if B wanted. I think that was in clause 4. Nicolay then sold to Thompson on the basis that Thompson would uphold. So first it goes from Bar to Nicolay and then Nicolay to Thompson. So it's kind of this chain of events, right? But then Thompson agrees and is sold this property on the basis of upholding Bar's interest, being the interest to repurchase. And clause 4 in their agreement acknowledged this, right? Bar did not know or could have caveated. Bar did not know or could have caveated. The T then wrote to Bar, the Thompsons rather wrote to Bar, confirming clause 6 was recognised, and Bar sent a deposit. Thompsons returned and reneged. So, as I mentioned before, there are different interpretations and different ways in which you can find that this is problematic, but one of the ways, which is what we're going through now, is that it was problematic by reason of being a fraudulent agreement to uphold and then reneging after. And alternatively, there is the ability to make a claim for fraud by misrepresentation through an in personam claim, but we are not going to talk about in personam today. But it'll be important later on. But yeah, as I said earlier, always go through both of them and kind of be aware of these different options. Actually, with it, whenever you have an indefeasibility question, chances are to be a very large question with 30 marks allocated or something. And what you're going to want to do is you're going to want to be able to step through basically all of the different claims that are being made, because there probably will be a lot of claims being made. Uh, okay. Or not claims being made, rather, just avenues for finding an exception on the facts. And often the kind of a distinguishing factor you could do is being able to recognize which one is the strongest in the circumstances and maybe being able to link it closest to a bit of case law. I remember in my exam there was a false attestation claim which seemed very, very strong at first glance. And I remember thinking, oh yeah, this is the one that I'm going to put down at the end as being the strongest. But then I remembered that I think it was a clerk in the case in the exam, and there was a distinction on the facts where the clerk in the case I was using as the basis for my argument was, I think, a first year and very, very, very junior, and I think the employee or the agent in the other case was much more senior and knowledgeable, and I think that had some bearing on my answer. I think it changed my mind, and I ended up arguing, I think mostly on an in personam basis because I think it was quite strong. Oh no, I argued mostly on, we'll talk about it in a moment, but mostly on a failure to verify under the new verification of identity requirements in section 87 of the TLA. But yeah, what I mean to say is essentially these questions will often ask you to, it's not enough to just kind of point out, oh, this applies or this might apply. You have to be able to identify, you know, which is the most useful and in which respect it applies with relation to the case law in such a way that you can distinguish between two different points or two different arguments and say, well, no, this one is a little bit stronger because it lines up more with the arguments of, you know, some case that you're analogizing with. And I'd say, you know, people might say, oh, this is true of all law exams, but no, not really. I think Property B really emphasizes that point, and I think it's important to make that distinction because otherwise you might kind of, especially in an exam, just kind of gloss over things that should be dealt with in more detail. Next, we have knowledge of fraud. Obviously, we have actual knowledge, where the plaintiff will argue that the defendant had actual knowledge and that the party procured their title by fraud, and therefore the defendant is inculpated in the fraud, and therefore the title would be defeasible, which it would be. Reckless indifference is a little bit more complicated. The plaintiff will argue that the defendant's title is defeasible for fraud because their suspicions were aroused by the problematic conduct, but they abstained from making further inquiries for fear of learning the truth. So this is one of those things where it'll be someone with access to something or something which will enable a registration to go through, and the defendant is, you know, is sufficiently aware or sufficiently indifferent to enliven this provision. Alternatively, the defendant will counter that whilst they may have acted with a lack of vigilance, there was no calculated ignorance on the facts. So, like, where this is something that will come up is with banks, right? Like, calculated ignorance would be where they intentionally let their staff act in a way where they can, you know, obtain registered mortgages, but, you know, if they have like a policy or something. But if it is just genuine lack of vigilance, then you might not have a case here. You might have something for attestation or for agency fraud, but probably not for direct fraud through indifference, because it doesn't really align with direct fraud. And they will argue that they've acted honestly and reasonably because their conduct wasn't problematic, and look at pyramid for that. And then you'd say the mere fact that the registered proprietor could have discovered fraud if he had been more vigilant and made further inquiries does not prove fraud in of itself, and you'd cite Assets Co for that. You know, less than meticulous practices will not constitute fraud. I'm citing Grigich there, but Grigich is actually a very problematic case, but they make the point in the judgment in Grigich that the practices were it wasn't a matter of, you know, a non-meticulous practice, they were outright problematic. Okay, then we have Pyramid v Scorpion Hotels. I actually do wonder, I might just briefly go through this now, and I'm going to go through it again later, just to help you guys kind of stay on top of it. But yeah, Pyramid had a mortgage over Scorpion Hotels land and wanted to exercise G as Scorpion Hotels had defaulted. The mortgage, the wait, sorry, my slide is playing up. Um, yep, the mortgage had a common seal affixed by Lewis, the director of Scorpion Hotels, and was attested by Lewis's wife, who was not a director and had no authority to sign. The Scorpion Hotels argued that the mortgage was defeasible for fraud, as Lewis was on a frolic of his own, and Pyramid should have done an ASIC company search and realised wife was not a director, or Pyramid should have obtained a copy of document authorising entering of mortgage. Yes, but obviously here it was held to not be defeasible, as there was no actual dishonesty or moral moral problems, and there was no evidence that Pyramid was suspicious that his wife was not a director or that the mortgage was not authorised. It was a mere lack of vigilance. Reasonable steps to confirm ID. We'll talk about that later, towards the end. But yeah, for knowledge of fraud, really, like, I've always found to kind of be a funny one, because like it kind of matches up or lines up with the requirements in agency fraud at a lot of times, or it often kind of cuts across everything, because often there will be some kind of, often there won't be actual knowledge, but you'll kind of have an argument for reckless indifference and you have to bring it up. But it is quite hard to make out because it kind of necessitates a degree of moral, problematic behavior. But the thing is, right, so it's kind of easy to identify in a sense, because you have to be able to look at it and say, well, they stood to gain through this behavior, and it is clear that their conduct was deliberately lazy or ignorant, as they understood that this ignorance or lack of care could lead to a profit. And I think that's the important distinction. It needs to be a deliberate lack of care or a deliberate lack of vigilance with the hidden intention of gaining something from that. And without that, you can never have knowledge of fraud made out, at least without going onto an agency provision, which would be a different exception. But yeah, so then we have false attestation. So false attestation is quite a fun area. Actually, I think you guys might have changed the cases slightly. I think either is it Diaga, Russo, or Grigich? I think one of these cases isn't on your reading guide anymore, which is sad, because, well, maybe not, because it means less work for you guys, I guess. But one of these cases is no longer on the reading guide. But I'm going to walk through them anyway, because I think they're kind of instructive in regards to, like, you're not going to get penalised for knowing them, and I don't think they'll make a question which directly invites you to talk about them, but they are instructive for understanding what it means to defraud the register. So, attestation, and this is kind of very important, and you'll say this when you write your paper, you would always start by saying, attestation is not a mere formality. It is a fundamental part, well, don't say exactly what I'm saying, because that'd be cheating, but something along these lines of attestation is not a mere formality, but a fundamental part of the conveyancing process, Diaga. The plaintiff will argue. I don't usually like to say will argue or will not argue. I often set my notes out that way because I think it kind of helps me kind of see it, but I would often kind of just go, it is arguable that the agent, whoever their name is, Miss Smith, has acted fraudulently and improperly attesting the signatures of X, Y, and Z on the document. And then the defendant will counter that while they may not have acted meticulously as they could have, this does not equate to fraud. And then you will say, on the facts, it was reasonable for the agent to believe that the signatory was entitled to sign and not an imposter. So this always comes up in the context of somebody signing something and the person who is, conveying it or seeking to obtain the mortgage, usually in a bank, should have been aware of some kind of problematic behavior. or should have been more vigilant to the behaviour. Uh, and then a person who attempts to register a fraudulently obtained document is not guilty of fraud if he honestly believes it was a genuine document which could be properly acted upon. So what does that mean? Basically, if you are a lawyer, or if you're anyone, and you're in a position where someone is signing a document which you are going to register, and then you go and register that document, but in the process in which it was signed, you considered it to be suspicious or problematic in any way, that enlivening of that thought of questioning the signature creates an obligation not to register it, because you cannot defraud the register. And if you do, you have defrauded the register, and it will be defeasible. It will not be an indefeasible title. Very, very important, and I'd say it's one of the best ones to make out, because it is quite common. So then we have a number of different ways in which to create knowledge or to find knowledge on the facts. I've set out in stretched font a number of cases and ways in which to determine this. So I don't know whether I go through these now or I wait. I'll go through them now briefly, but in Rousseau, the attestation must be accompanied by a willful, conscious disregard and violation of the rights of other persons. It must be dishonest, right? If they have no knowledge of false attestation, it can't be fraud. So if you are fully unaware, if someone comes in and says, I am, Johnny Smith, and I want to get a mortgage over Johnny Smith's title, and you comply with the Section 87 verification identity requirements, and you do all of that stuff you're meant to do, but and they sign it and you believe it honestly, you're fine. Then in Diaga, so the employees allowed a mortgage to be registered despite knowing that it was falsely attested. They didn't know of the forgery, but defrauding the register, they did not have an honest belief that the documents were genuine. Diaga asked a used car salesman to get finance to buy a gym, a used house as security, and Diaga signed, but not Mrs. Diaga. And then when they went to separately convince Mrs. Diaga to sign, they forged it. AGC employees saw that her signature was unattested and allowed it to be attested right there by the wrong person, therefore falsely, so they had knowledge of the false attestation. Then Grigic, attesting to the effect that someone is personally known does not require a degree of intimacy such familiarity. Attestation not fraudulent unless a tester knows or is reckless as to whether the person signing is who they suggest. Fine if there is a reasonable belief in identity. I'm kind of brushing over these and just kind of reading them off quickly because I don't want to dwell on them now before I go into more detail into the facts of these cases later on in the lecture. Because how I'm structuring this is I'm going to kind of go through all of this briefly, the kind of principles, and then I'm going to skip right back to the beginning with the context of the cases, because this is the part of Property B that gets very case heavy and it becomes quite valuable to understand that. But then obviously we have understanding consequences of false attestation. So in this one it was a young clerk who was, I think, first year on the job, and she was aware, but then it was held the solicitor didn't know, and Rita was not dishonest, she was not aware of the consequences, and there was no intention to defraud or conscious impropriety. This is what came up in my exam, but the context, I think even the name was the same. I think it was Rita, but the point, and I think they were trying to get that analogy to be made, but the important point to make was that it was a different circumstance, and there was kind of a difference in the role. So you will look here, when you're looking at the person that's allowing it to be signed, you will look as to whether they are in a position to understand the consequences of what false attestation is. Obviously, a solicitor or a bank officer will always have that knowledge, but maybe more junior, interns or something can be found to not. And then aggregation of knowledge, is it possible? It might be possible to aggregate the knowledge of the agent and employee of the agent. It's left open, even if one could, wouldn't matter here. So maybe you might get a question about this, where you can aggregate the knowledge of the different parties involved. Hasn't been established, but if you were able to bring in Rousseau and say that they've mentioned this possibility and use it, it'd be very impressive to the examiners, and I'm sure you do very well if you were at that point. Okay, so those are the different kinds of fraud, kind of specific immediate fraud by the by the party being registered. Now we have fraud of an agent, which is a bit different. Okay, so once registered, okay, well, this is kind of going back to our basic principles, but always start by saying that once registered, titles will be immediately indefeasible unless a relevant exception applies. Breskvar, and then section 42. Here, we will be looking at the exception of fraud, where an agent is engaged in or known of fraudulent conduct, and whether this can be brought home to the registered proprietor, rendering their title defeasible, i.e. vulnerable to attack. So, there are 3 key points to consider here. Is there an agency relationship? Is there an agency relationship? Has the agent acted fraudulently? And did an agent have knowledge of the fraud? Okay. So, what is an agency relationship? There are 3 kinds: express, de facto, and implied. Express is pretty rare because it's very unlikely that the person is going to say, I authorize you, my friend, to go and defraud our clients at the bank and get fake mortgages. De facto, this is where you arming conduct, where you arm somebody, so that it looks like so to a third party it might look as though the agent has the authority to act in a certain way. For instance, Mrs. Glass in Low-Q was armed by PSR to commit fraud. Or consider dollars and cents, where the bank gave Nathan. So dollars and cents is a New Zealand case, but it can be instructive because the bank gave Nathan, the son of the people of the registered proprietors, they gave them an instrument of mortgage and asked him to procure his parents' signatures, and there was a clear implied authorization to represent dollars and cents by doing that. They kind of created his role of agency. Then we have implied agency, which is the most common, where if you authorize an agent to sell your land, they may be impliedly authorized to allow inspections, advertise, etc., but they would not be authorized to sell the clothing you've left in the cupboards. So it's a question of whether the scope of agency. We'll get a bit more into that in a moment. What else? Yeah, the case of Casgrain has a lovely analysis of what exactly is agency in the context of property law, if you want to look at that. Then we have circumstances where the agent themselves is fraudulent, right? So we've considered what an agency relationship is, and now we want to think, okay, well, say in our question, the agent has been fraudulent in their behavior. It is then necessary to consider whether the agent has acted within the scope of their actual or apparent authority granted by the defendant. So this links back to the previous slide as to what kind of agency do they have. So we're looking at scope. So if they have, then the principle of respondent superior will apply, meaning that the principal will be liable, or the registered proprietor will be liable for the fraud of the agent. An exam tip from Schultz: forgery will not be in the scope of agency, meaning that it will not be deemed to have been communicated to the registered proprietor. So if the agent has forged something in the process, unless the registered proprietor has actually authorized that, which will never happen, it will not be deemed to have been communicated to the registered proprietor as who would do that. Therefore, in cases where an agent has committed forgery, it is likely that the fraud will not be brought home to the registered proprietor. If this has happened, consider false attestation or an in personam claim. This Schultz was they set this out there. It's quite an important point because often you might think, oh, well, the agent's committed forgery, therefore they've acted fraudulently, therefore we can do, respondent superior, therefore we have a defeasible title. But it doesn't work like that, because it is deemed that the scope of actual or apparent authority will never include, or forgery will never be within the ambit of that scope, and therefore it cannot apply. Also note that fraud of an employee of an agent is likely too remote to be brought home. So if there is a principal and then an agent, and the bottom agent does something fraudulent, it's probably difficult to say that it was communicated through those layers. You cite Russo for that, and obviously here it was the law clerk Rita, because we're citing Russo. An agent acting fraudulently for themselves, there's a point of difficulty. So for the Australian approach, as set out in Schultz and affirmed in Cassegrain to apply, it is necessary that the agent does not benefit from the fraud. Otherwise, they can say it's a frolic of their own and they're kind of gaining something. So it's actually quite rare for this to happen. But, exam tip, if you're answering a question where the agent benefits, apply the New Zealand critique of Schultz from Dollars and Cents. So it's kind of always nice when you get this on an exam because you just know, oh great, now I can yap about the New Zealand authority that we think is, well, like at least the academic world largely thinks should be, I don't know, interpreted or incorporated into Australian law, and that being that regardless of benefit to the agent, if acts are sufficiently connected to the task which they were tasked to do, the fraud can be interpreted as a mode of performing the task and brought home on that basis. This won't be binding, but it is a powerful critique that may influence a court's decision, as I said a moment ago, because it's New Zealand authority. Never forget, it's New Zealand authority, but it's good authority. Where an agent has knowledge of fraud, so it's a little different. If for instance, the agent has knowledge of fraud, they are under a duty to communicate this knowledge to the principal. There is an irrefutable presumption that they have communicated their knowledge, which will render a title defeasible for fraud. In Schultz, evidence is not admissible to prove that the agent did not in fact communicate his knowledge to the principal. So there is a presumption that where they have actual knowledge, they will always communicate it. Then we have willful blindness, is getting back to kind of what we talked about earlier. Knowledge may be imputed even where the agent does not have actual knowledge, but has deliberately closed their eyes to the fraud, diaga. This is most likely to occur in situations where the defendant stands to benefit and therefore has been intentionally careless. But, maybe they may stand to benefit, which, comes back to the criticism we talked about from Schultz, but, again, dollars and cents. If the agent is involved in some way, well, as I said at the bottom of the slide, always include the analysis from dollars and cents. Then we have the fact, so now we've kind of actually gotten through the basic kind of outlines of the different kinds of fraud, including fraud of the agent, verbal misrepresentation, false attestation, and knowledge of fraud. So we've kind of gotten through all of that, which is lovely. But now we're going to get to a couple of other little things, namely that fraud must be operative. I've mentioned this briefly before, but fraud cannot be something which has no bearing on the final outcome. So, what does that mean? The case for this is Ferguson, and in Ferguson saw the bank manager about a loan. BMX prepared a statement of position based on Ferguson's info provided. He then the manager forged a signature, fraud 1, and he was later fined for a different reason. BMY asks Ferguson for valuation, writes down a figure 200% more. Ferguson is unaware. This is fraud 2. It was held that it's not statutory fraud, as neither of these operated on the mind of Ferguson. He was unaware of either fraud and was not induced by either fraud to his detriment. It was merely a statement of position and valuation which did not alter his rights or obligations. The only effect was that it was easier to get a mortgage, which he wanted anyway, right? It might be operative where it contains a serious mistake regarding the contents of the mortgage, maybe, a mortgage over more of the land or different terms of the mortgage, or whether there was a lack of consensus in the first place, or where there was an increase of liability of individual or affecting their legal obligations. But yeah, that's just kind of a small point. I've never really seen it be massively important, but it will be obvious where it is not important. If it says like, Alexander came into the bank and the bank manager showed him a painting, or I don't know, the bank manager, it has to be something that seems to be inducing but isn't inducing, and then say it says Alexander was desperate for a mortgage, he desperately needed the mortgage, and he comes in desperate, and the bank manager kind of, forges some document that makes it seem more enticing to get a mortgage, it likely won't be seen to operate on their mind. Okay, so, but yeah, you can always just go back to Ferguson for this one and have a bit more of a look if it's not clear. But yeah, now we have section 87A1, which I mentioned I think it's come up in a few weeks. I'm sure you're all somewhat aware of it by now. But this is a very, very important new provision which requires that when executing or varying a mortgage, the mortgagee must take reasonable steps to verify the identity and authority of the mortgagor to ensure the mortgagor is the registered proprietor of the land which they are seeking to have mortgaged. That is security for the payment. Section 87A(1). This was added in 2014 to avoid the Grigich debacle. Good thing to know in an exam, actually, if you wanted to. Well, actually, how important is kind of historic. If you've got time, probably not the first thing I'd be doing, but if you have a moment. Then, what are the reasonable steps under Section 87A(1)? CNF nominees sets out two ideas. It must be verified by photographic identification and comparison of likeness that the mortgagor is indeed the mortgagor. It must be verified that the identified mortgagor is indeed the person executing the mortgage. I would cite those if I was applying this, because that way you have the case authority and you have the statutory authority. You have a way to do it, and you have a way to apply the actual statute that you are looking to apply. And then in assessing the reasonable steps, see the requirements allowed under Section 106A, which took effect from December 2015. And we have that the mortgagee can apply the verification of identity standard or take other reasonable steps to verify. So what is the standard? The mortgagee. So other reasonable steps would be if you knew the person your whole life and you were fully aware of that context. But generally speaking, it'll be the mortgagee must verify in a face-to-face interview. Very important. This will be obvious on the facts. If photographs are presented, it must be a reasonable likeness. So if they come in and they say, I lost some weight, cut my hair, shaved the beard, you might tell them that they need to come back with renewed information. Mortgagee must ensure that the documents produced are original and in one of the categories, and must be reasonably satisfied that a prior category cannot be met before using a subsequent category, and must sign originals of all ID documents and retain copies. These are the standards which must be applied. Then, if they fail to take reasonable steps, the registrar may either refuse to register or, very importantly, remove the mortgage. If removed, the mortgage is void and the mortgage is no longer indefeasible and is subject to attack. And then Section 87A(4), the registrar can refuse to register or remove a variation if a variation is void. So, what are the practical consequences of fraud? Well, if fraud is established, any amendment to the registrar procured or made by fraud will be rendered void as against the plaintiff's and defendant's title is defeasible. If the plaintiff was the previous registered proprietor, the transaction will be set aside for fraud, and it will be registered to, and it will be rectified pursuant to Section 106, and the plaintiff will have full legal title returned to them. If the plaintiff is a joint tenant, the transaction can be set aside against their share of the title. Important to note that just because one joint tenant has received title by fraud does not automatically render both joint titles defeasible. You'll always have to keep the interests of the third party in mind. And then the plaintiff had a prior unregistered interest, i.e. transfer, lease, etc. The defendant's title will be encumbered by that interest. And then for mortgages, if a mortgage is found to be void for fraud, it will not operate as a charge on the land, blah, 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 it's removed. Remember, if a subsequent purchaser is innocent and has been registered as a proprietor, there will be no remedy. If a subsequent purchaser is not the registered proprietor, it will become a priority dispute. So if there are two people, if they're purchased but they haven't been registered yet, this goes to a later topic. I think I said topic 5 because it's probably what it was when I did it, but I think it's now topic 8, something like that. But yeah, if subsequent purchaser not registered proprietor will go to a priority dispute, which is a contest between two interests. We've talked about those previously. And then we have the assurance fund. If title is indefeasible and fraud cannot be brought home, P may have to pay a claim pursuant to Section 110(1)(b) or C from the assurance fund. Actually, let me just pull up that really fast. Section 110. Let's see. Insurance. Indemnity. Yeah. Just we just cite that provision when we do this. Yeah. So just remember that if the title is indefeasible, and there was some issue with bringing home fraud, there might be a claim under section 110B or C. 110B being where there's been an issue with the amendment of the register, and and that's caused loss to the party. And number C being where there has been an error or omission or misdescription in the register or the registration of any other person as proprietor. Yeah, that's fairly straightforward. Okay, so that's a lot of content we've gone through today. I might just recap it for you all briefly, so we can get into the cases with a sense of familiarity. Statutory fraud. What does fraud require? It requires dishonesty of some sort. Can it happen before the transfer? Of course. Can it happen after? We don't know. Maybe. There are three kinds of fraud here: verbal assurance, knowledge of fraud, or false attestation. Apply the relevant tests. Locu and Barvi Nicolai note that for fraud that happens after, there is unsettled law, but apply both. Knowledge of fraud, actual knowledge, very persuasive. Reckless indifference, much less so, requires designed or calculated ignorance, pyramid. Knowledge of fraud, false attestation. Did they act in a way where they knew the signature was false and nevertheless registered the instrument, and in those circumstances were they a person who we would expect to be aware of the consequences of such behaviour? Fraud of an agent. 3 points. Is there a relationship, expressed, de facto, implied? Have they acted fraudulently themselves? Were they acting in their own interest? Apply the dollars and cents New Zealand critique of Schultz, and apply Schultz, but always note that Schultz is the current authority, subject to being overturned. But remember that that wherever there has been benefit to the agent, it will not be able to be found to be fraud, as they have acted on a frolic of their own. And again, as I said a moment ago, apply the New Zealand critique. And then where an agent has knowledge of fraud, was it actual knowledge, in which case he will be assumed to have been communicated back to the principal, that being the registered proprietor, and it will therefore be defeasible. Or was it willful blindness? Once again, we go back to this question as to whether they have closed their eyes for some kind of benefit. And all of this invites the dollars and cents critique. Fraud must be operative, and we now have section 87 for the verification of identity. Very important to apply this accurately. Then we have the practical consequences, which includes the ability where you have not been able to make a title feasible through applying an exception to have a claim pursuant to the indemnity fund, or the assurance fund rather, under section 110B or C of the TLA, where you have suffered a loss. Okay, so now we are on to the cases. Sorry, talking non-stop for 50 minutes always, or an hour, always fries my vocal cords, and I kind of get funny by the end. But anyway, we have, as we mentioned before, Assets Co. It's just a quote. I'm not going to go into this one in a whole lot of detail, but good to have in your notes and be aware of. Then we have the Privy Council in locu. So let's go through the facts. USOP is the registered proprietor of 322 acres of land in Malaysia. He enters into a transaction with locu, whereby locu becomes the owner of 58 acres of land, but he does not register his interest because the documents themselves were defective. Sometime later, so no fault of his own, sometimes later, USOP began negotiating with PSR. USOP refused to sign unless PSR gave an undertaking to protect LoQ's possession of the 58 acres of land. And the price itself, which they paid, was discounted to reflect that 58 acres. After PSR registered, they made a low offer to LoQ, and then of course LoQ rejected, and then they brought an action for possession. LoQ brought an action for fraud in retaliation. The holding was that this behaviour was fraudulent. When the agent of PSR, Mr. Glass, made a statement on behalf of PSR in negotiations, it falsely and fraudulently asserted they intended to respect LoQ's beneficial ownership. Beneficial because it had not been registered, because the documents were defective. The TLA was never intended to permit a fraudulent person to shelter behind registration. As such, the Privy Council ordered that the PSR transfer the 58 acres back to LY. Ratio being, if a person makes a fraudulent representation prior to registration, rendering it easier for them to secure a transfer of land even if they pay, this is still within the definition of fraud. Important to note, this is a Privy Council case from Malaysia. LATEC investments. This is a kind of short overview of this case. We'll look at it in some more detail in later weeks, but a mortgagee was selling property. The mortgagee decided to sell the property under power of sale to a subsidiary company. So it conducted an auction where the reserve price at auction was so high that it was guaranteed the property wouldn't sell. And then, of course, the property passes in, and after auction, the mortgagee is sold to a subsidiary, Southern Hotels. The mortgagee had acted fraudulently as Southern Hotels was in on it. Section 42 applied, and the mortgage was indefeasible. Now we have a heftier case in the form of Ferguson, Bank of South Australia v. Ferguson. This is what we were talking about earlier with regards to the operation of fraud. So Ferguson was the registered proprietor of some rural land in South Australia. Ferguson then registered a mortgage with the Bank of South Australia for $250,000 because Ferguson is a potato grower who gets a big contract and needs some money. Ferguson then defaults, and the bank wants to exercise their power of sale. And then he goes on and says, well, no, you can't do that because you are guilty of fraud. The fraud alleged was fraud perpetuated during the loan period where they had signed Ferguson's signature to a statement of position on a loan application, an internal bank document that wasn't operative in creating the mortgage, which was sent from the local branch to a bigger office. The manager had changed the valuation on the land, and the old manager was removed, and the new manager made some new variations in pencil to the internal document sent to the bigger office. He changed the value of the land to an amount much higher than Ferguson had stated in his cash flow documents, and Ferguson was unaware of any of these alterations, which is key here. So none of these acted or operated on his on the registration or on his mind. They increased the valuation or forward signature, but the changes did not affect his liability in any way. Key conceptions. Ferguson's signature to a statement of position was forged by the bank manager and used to access loan application. As we've said. So the question becomes, was the bank fraudulent? Clearly no. The bank was not guilty of fraud. The fraud was not operative because it did not operate on the mind of the person said to be defrauded, and didn't induce detrimental actions by that person. The forward signature did save Ferguson the trouble of coming back from the farm. The signature didn't operate to Ferguson's detriment. It was not used to harm him, cheat, or act dishonestly towards him. It was merely, documents being passed around within the bank. It's not proper practice and it shouldn't be done, but it didn't operate on Ferguson. And then finally, there needs to be some connection between the fraudulent actions and the detriment of the person alleging fraud. Don't take a case too literally. Just because there's been forgery, just because there's been something improper, doesn't necessarily create fraud. Even if eventually there was fraud, certain actions must be operative in order to be valid. Important, and can save you a lot of time in the exam if you can figure out that something has not operated on the mind or has not operated on the eventual registration. Okay. Oh, I'm so sorry. That is quite small. Maybe some of you will want to... Actually, you know what I'll do? 1 second. Oh. It's not coming through, but I just made it bigger. Oh well. If you want, you could make it bigger. Yeah, whatever. Yeah, that isn't great, is it? Can I just give me just a second just to fix that, just so for you guys' benefit. Um, mhm. Mm. Why is that not coming through? Probably because my computer thinks my word's unlicensed right now. I'm just reopen this PowerPoint. Open. Okay, here we go. Hopefully that's somewhat better. Just make it a bit larger. Okay, and then we'll go back to share. Okay, fantastic. Okay, cool. So, Barbie Nicolay, very important case. Barbie Nicolay 2. So let's go through the facts of this one. Mr. and Mrs. Barr acquired some land in WA. They already owned a general store. They wished to buy a block, 340, which at the relevant time was owned by the Crown. The Barrs acquired a license from the Crown to occupy that land. That license contained a right to call for the Crown grant of fee simple if a commercial premises was erected by a specific date. The Barrs needed money to make this improvement, and the Barrs' estate agent introduced them to Nicolay, an overseas investor. Nicolay agreed to this. The Barrs sold lot 340 to Nicolay for $32,000. They got ministerial consent to do this. So, very serious stuff. Nicolay leased the lot back to the Barrs for 3 years. After 3 years, the Barrs would repurchase lot 340 from him for 45 grand. Clause 6. The court regarded as imposing on Nicolay an obligation to resell. This was an executory contract for sale, meaning that the Barrs owned the land in equity. 1 year later, Nicolay sold the land to the Thompsons for 40 grand. At the time of this purchase, the Barrs had fallen into financial trouble, and it did not look as if they were going to be able to exercise their right to repurchase. So the Thompsons made a gamble. They thought, oh, Barrs look like they're not going to be able to pay it off for 42 grand, so let's just sneak in there and get the property, right? The Thompsons, were aware of this, and the Nicolays only agreed to the agreement, to the purchase, or the contract, if the Barrs' rights to purchase was preserved. Clause 4 of their agreement, so we have Clause 6 for the Barrs and the Nicolays, and then Clause 4 for the Nicolays and the Thompsons. And Clause 4 of the agreement of transfer acknowledged the relationship between the Barrs and the Nicolays. Thompsons became the registered proprietor, importantly subject to this agreement. The Barrs were unaware of this transaction. After the Thompsons registered, they wrote a letter to buyback arrangement confirmed, but at a higher price, greater than 45 grand. Barrs' solicitor wrote back saying they had agreed to 45 grand and sent a 10% deposit, the initial agreement they had. The Thompsons returned the deposit and said they had no intention of selling and relied on registration to defeat the Barrs' claim. The Thompsons have an immediately indefeasible title unless the Barrs can bring them within an exception of indefeasibility, e.g. fraud or in personam. So immediately upon reading this question, obviously these facts, obviously the Thompsons have acted improperly. But the question is whether their registration is able to be attacked. And as we will see in a moment, it can be, definitely. So, first of all, fraud. We're investigating the difference between notice and fraud. Essentially, the Thompsons knew of the Bars and Nikolai's arrangement. Notice of prior interest is not fraud. Notice of fraud is fraud. Can statutory fraud come after registration? There is an issue because there was evidence at the time that the Thompsons purchased their interest, and that the Thompsons did not intend to renege. Not like in Like You. The Thompsons were hoping and taking a punt that the Bars would not be able financially to exercise their buyback right. It was not until after registration, when the Bs demanded property be sold for 45 grand, that they decided that they were going to not honour their agreement. If this was fraud, importantly, it happened after registration, as they formed the requisite intent later on in the process. High Court found in favour of the Bars, but for varying reasons. All judges found there to be a valid in personam claim. 2 of the 5 judges found that the Thompsons, as I mentioned before, had been guilty of statutory fraud, and they found this because it was fraud pursuant to Section 42, not mere Section 43 notice, because Clause 4 amounted to an agreement to take subject to the Bar's prior interest. 3 out of 5 of the judges did not find fraud and accepted the arguments by majority. These are the accepted arguments by the majority. The Thompsons argued that Clause 4 of their agreement with Nikolai acknowledged that the Bars had an interest of agreement with Nikolai. The Thompsons argued that it was mere notice, which isn't fraud, per Section 43. The Thompsons argued Section 42 does not catch fraud after registration, all of which is reasonable. However, Wilson and Toohey, the Thompsons bought the land in the hope that the Bs would not be able to exercise the buyback right, but did not intend to ensure the Bs could not exercise that right. This conduct was short of what was required for fraud. They all went on, however, to establish a in personam claim. Which view is correct? The Mason and Dawson view is controversial. It makes it easier to establish fraud, but undermines indefeasibility because it is easier to take people off, or take the Thompsons off the register. It would mean that every intentional breach of contract could be treated as fraud. In their analysis, Mason and Dawson paid more attention to the provisions surrounding, e.g. Section 43. Because cases since this have gone either way. New Zealand and some Australian cases have preferred Mason and Dawson's approach, which is something you might want to note in an exam. But you would note both approaches regardless and pick which one you think is better. Then we have Pyramid Building Society and PBS and Scorpion Hotels. The Scorpion was the registered proprietor of some... Oh, my slide's not moving. There we go. Registered proprietor of some land and had been loaned some money by Pyramid to register a mortgagee over the property. Pyramid, the registered mortgagee over the property. Pyramid tried to enforce the mortgage, and Scorpion responded that Pyramid had been fraudulent because Scorpion had not properly executed the mortgage. Mary Lewis, the wife of Scorpion's director, and Peter Lewis attested the mortgage. Scorpion had never given these people authority to execute a mortgage. Scorpion therefore argued that the mortgage was void and Pyramid's interest indefeasible. Ordinarily, mortgage documents would be immediately indefeasible. Scorpion's arguments were: Pyramid knew or ought to have known that the loan money were going to be used for an illegal purpose. Before loan and mortgage transactions were settled, Pyramid did a company search and should have discovered that Mary's signature in attestation was not valid as she was not a director. Pyramid chose to settle the transaction without obtaining a copy of minutes of the board of Scorpion authorizing the transaction. Scorpion therefore argued that Pyramid had acted in willful blindness and reckless indifference. However, the court found there was no fraud. Pyramid did not deliberately abstain from making inquiries for fear of learning the truth. There was no evidence that Pyramid knew that Mary wasn't a director or a loan and mortgage. This is all going to the idea that you don't have to scour the earth or inquire in every way, shape or form as to whether there has been any kind of issues to be found to have knowledge of, to be safe from this provision, or to be safe from your title being found defeasible. As long as you didn't willfully act with reckless indifference, you will be safe, or the person in question will be safe. At its core, Pyramid would have discovered the mortgage had not been properly attested if they had made further inquiries. But as I just said, this is insufficient for fraud. Pyramid could therefore enforce its mortgage as indefeasible, and the cases have suggested that the mortgagee could have chased any shortfall under a personal covenant, but that's kind of not that important. Okay, so now we have a number of other cases: Dollars and Cents, Schultz, AGC, and Grigich and Russo. I'm going to step through these one by one. The reason I'm not putting everything on the slides is I'm actually not entirely sure as to the bounds of what I'm allowed to do as a tutor, whether I can, because if I put everything on the slides, it might be problematic in the sense that I'm giving you my case notes on everything, and that might be allowed under student conduct. I think I can do it within reason, like a couple of cases, but I think if I do every single case, we could get into some trouble. So I'm just going to limit myself and hold back, but I'm still gonna read from them and kind of do a little bit of analysis as I go of exactly what I think is happening in these cases. So first we're going to look at Schultz v. Corwell, which we've briefly discussed previously. But in Schultz v. Corwell, Mrs. Schultz had some money to invest. She decides to go to her usual solicitor, who then sends her to another solicitor, Mr. Galia. Mrs. Schultz sees Mrs. Galia, who suggests that she lends the money to a company called Corwell Properties, so Schultz v. Corwell, to be secured by means of a mortgage over Corwell Properties land. Mrs. Schultz, Corwell Properties, the registered proprietor of the fee simple. Mrs. Schultz then gets a registered mortgage. Galia, secretary of Corwell Properties, forges a signature of his mother, Mrs. Galia, who is a director of Corwell Properties, to the mortgage of Mrs. Schultz, affixing a co-seal and registering the mortgage. Note that Galia had custody of the certificate of title. Corwell now has a mortgage, which they did not authorize or know about. A few months later, Mrs. Schultz dies, but probate is obtained, and Mrs. Schultz and Mr. Schultz steps into her shoes. Galia has clearly acted fraudulently. He was going to make the repayments and hope that nobody ever found out that he had done this. No one will find out unless they do a title search. Eventually he resigns as secretary, and someone who replaces him asks where the certificate of title is, because the company has decided that they want to sell the land. But, as mentioned previously, the certificate of title is with the Schultzes because they are the first mortgagees. Galia produces the title, and by the time that he does this, there is a discharge of mortgage. Galia went to Mr. Schultz and said that the company had sold the land. And he says to sign this mortgage and discharge, and we will repay you out of the proceeds of sale. Mr. Schultz signs a discharge of mortgage, and Galia says, "Don't worry, I'll reinvest your money on your behalf." In reliance of that, Mr. Schultz does not execute a discharge of mortgage, and Galia registers it, but never repays or reinvests the money. Discharge not forged, but fraudulent, because it was he lied to Mr. Galia to obtain it. Or rather, Mr. Galia lied to obtain it. In both cases, Galia has been the fraudster, getting up to a lot of improper behaviour. Mr. Schultz argues whether or not there is a mortgage, there is a discharge of mortgage that is registered, albeit problematically obtained. Mr. Schultz argues that he has had an indefeasible mortgage, and Corwell argues that the discharge is indefeasible. So it's a lot of facts. So the question is, and the same question arises in both instances of both transactions, rather, as to whether the fraud is able to be brought home to the principal. And the same question is, was Galia acting as a solicitor of Mrs. S to acquire the mortgage and the secretary of Corwell Properties? Was he acting as an agent to both sides of the transaction? Because, he's kind of here in both ways. So, in the first transaction, Mrs. Signature is forged, can the fraud be brought home? We have to ask, well, is the forgery to be imputed to Mrs. Schultz? Was the agent acting within the scope of authority that Mrs. Schultz gave him when he committed this fraud? No, clearly not. It was not within the scope of his actual or apparent authority to forge the signature of his mother to the mortgage. The forged execution of the mortgage was in furtherance of a criminal abuse of his custody of the title. Therefore, they found a frolic of his own. Very important kind of point, because he's benefiting from this. You can't argue that this was forgery for Mrs. S on her behalf, as fraud couldn't be attributed to Mrs. S on agency principles. Then you ask, well, what if the agent knows of fraud? Well, obviously he knew as he committed it. This second framework kind of seems redundant, as his knowledge of his own forgery can't be imputed. This depended on whether there was a duty to communicate. But clearly, if he's forging something, that duty is kind of interrupted. And then Mr. Schultz wins this argument because the mortgage was forged, but the forgery of Galia can't be brought home. Therefore, the mortgage remains indefeasible. And then we have the second transaction, and you have to ask, well, is Galia's fraudulent discharge of the mortgage to be imputed to Cornwall Properties? I would ask the same question, such arguments as above, the same exact thing. Clearly it's fraudulent, but it can't be brought home as it's a frolic of his own. Yeah, I think that's just the kind of main point of this entire case. It's very long. Is just where a person acts in their own interest, on a frolic of their own, it cannot be brought home. So there are two limbs to fraud of an agent. First of all, the agent must be fraudulent, and secondly, where the agent knows that fraud has tainted the transaction, respondeat superior will not apply. As the mere fact that the agent has knowledge of fraud is insufficient to impute fraud, there must be an additional circumstance, a duty to communicate. If the agent is under such a duty, then the agent is presumed to have communicated the matter to the principal, and the presumption is irrebuttable. There is an exception which is heavily criticised. If the agent is under such a duty, then the agent is presumed to have communicated the matter to the principal, and the presumption is irrebuttable. But if the agent, this is a, it's funny how hard they try to kind of prevent the title from being defeasible. And then, of course, we have the dollars and cents case, which is the kind of the yin to the yang of this case, wherein it was found that basically the son of two parents went off after obtaining the certificate of mortgage, or rather an unregistered mortgage documents, and he what does he do? He goes back to his parents, and I'm trying to remember the most important point that we want to talk about here for this case. It's a long case. Dollars and cents v. Nathan. I guess the short of it is Dollars and Cents, a finance company in Auckland, decide to lend money to Nathan. Nathan needs a loan to purchase some shares in a business, and he approaches Dollars and Cents, and they agree. And he says he's going to get his parents to mortgage their home. Then Dollars and Cents engages a solicitor, Mr. Thomas, who is going to act on their behalf. Valid agent. Mr. T and Dollars blah blah blah. Mr. T, Mr. Thomas, the valid agent, prepares documentation and arranges, problematically, for Rodney Nathan, to have his parents execute them. Dollars and Cents and Mr. T did not know that the parents had separated, but was still jointly on the title, separated for some years, and the mother lived elsewhere. Rodney goes to his parents' house, and the father signs a mortgage. There was some concern as to whether Rodney had exercised undue influence on his father, but the father died before the case was litigated, so there's no way of confirming that. So we just assumed that it was genuine. But the mother's signature was forged because Rodney knew that she would never agree to put up the jointly owned matrimonial home. Rodney sends documents back to Mr. T, and Mr. T notices that the signature has not been attested. Mr. T sends them back and says that they need to be witnessed, and then Rodney, gets a friend to witness them and says that they have been witnessed. Note that the father had the certificate of title and handed it over to Rodney. Mr. Thomas and Dollars and Cents have no knowledge of any of this. And eventually, obviously, Rodney can't repay after his investment, and Dollars and Cents wishes to exercise their power of sale. And the question becomes, is this mortgage defeasible? Well, Rodney is the fraudster, and he is the agent of Dollars and Cents. And we need to bring that fraud all the way back to Dollars and Cents, the financing company. There are two issues. Question one, was he appointed, expressly or by implication, to act as an agent of Dollars and Cents in its transaction? This is the first question in establishing agency. We need to scrutinize all the circumstances of the case to see exactly what it was that he was tasked to do. Well, did Dollars and Cents make it his task to obtain the execution of loan documents and the mortgage? Did they trust him with that function? And was he standing in the shoes of Dollars and Cents when he transacted with his parents? Well, it's kind of odd, because Rodney is the borrower of the money, i.e. he's acting for Dollars and Cents, then he is acting for the lender as well as being the borrower. The court did not take issue with this, however. A borrower can act for some purpose as the agent for the lender. And finally they found he was appointed to act as an agent for Dollars and Cents, and he was not acting entirely in his own interest, but as an agent. What he was doing was in his own interest because he wanted the loan security. He had an interest, but this was not inconsistent with him acting for Dollars and Cents. Mr. T merely giving Rodney some documents. Mr. Thomas merely giving Rodney documents to pass on to his parents to sign is not in itself sufficient to create an agency relationship. However, he could just be a conduit. It's always a question of facts, but ultimately, when you look at everything in combination, there is an agency relationship here, and therefore Dollars and Cents had appointed, expressly or impliedly, for him to stand in their shoes when dealing with the parents, because Rodney had done everything that needed to be done. And the second question is, was he acting in the course? So we've established that there's an agency relationship, express or implied. And the next question is, was he acting in the course of his agency when he committed the forgery? Or, like Mr. G from Schultz, was he acting on a frolic of his own? Court noted that this could be answered in a broad or specific manner. Broadly, Rodney, or Nathan, Mr. Nathan, Rodney charged by Dollars and Cents, he was charged to obtain this mortgage. More specifically, he was tasked to obtain his parents' signature on the mortgage and have them properly attested and get the certificate of title and provide the mortgage with insurance details. Court chose the narrower view, that forging his mother's signature, an act so connected with the authorization that it was an improper mode of performing them, is the forgery, was forgery, and was capable of being brought home. Ultimately, the court made the decision on the basis of policy, essentially deciding whether it was better for the bank or for the mother to bear the loss, and whether that kind of principle, who we should be looking to protect going forward. And in the context of Australia, this I guess would go to the Torrens aims, and I guess that's why in Schultz they found the way they found, in the sense that they were looking to protect the buyers or the purchaser or the loan or the mortgagee in these relationships. But the court found that Mr. Nathan's fraud, was within the scope of agency because the forgery took place to achieve the very thing that he was asked to do as an agent of Dollars and Cents. E.g., it was so connected with what he was asked to do that it could not be regarded as a mode of performing them. So always ask, is the connection sufficiently close with the tasks that the person has been authorized to do so that it could be said that the commission of the fraud was in of itself a materialization of the risk inherent in the transaction. But yeah, so his actions were an improper method of doing his job. There was vicarious liability, and the dollars and cents should expect to bear the responsibility where risks inherent in agency materialize. Dollars and cents should not be able to deny agency to get the benefit of indefeasibility. So obviously here is kind of a direct critique of the Schultz case, which we talked about previously, taking a much more restrictive view on the notion of respondent superior and vicarious liability, and they noted that Street was quick to find a frolic of his own and that Mr. G's actions were not for his principle but in order to further his own interests. And yeah, so Dollars implicitly criticizes the more lenient, through a more lenient analysis of the behavior. But always keep in mind that this case is a New Zealand case and it will not be binding for Australian cases. Okay. Where to now? So, we have a number of false attestation cases. I'm cognizant of time, so I may just talk about one of the cases. I don't think Diago's on your reading guide anymore, so I might not go through that in a lot of detail. I might just go straight to Russo. I think Russo is the one I'll talk about. So, in Russo, Mrs. Russo argues that attestation was fraud. In this case, adult children wanted a business loan and they needed some security, and the parent's signature was forged on the mortgage. Mrs. Russo's signature was on a business loan to the Bendigo Bank, securing a business loan to the daughter and son-in-law. Son-in-law was the one who perpetrated the forgery. She had never agreed to put the property up as security, and the first she knew of the mortgage was when the bank tried to enforce it against her. The mortgage transaction was done by a solicitor for the bank, Mr. Reichman, and Garada was was a law clerk and was an employee. At the time, she was only 19, so very young. Oh yeah, this is a point that I remember was on my exam. It was the age. They were only 19, and the point being, very inexperienced, and we, argue in the context of law and all these different things. They might be unaware of how attestation might affect it. So if you get a question where they mention the age and they tell you maybe she's 30, 28, 25, 30 year, whatever, you might have a stronger case. Anyway, it was argued that she had only been working for 3 years as a law clerk at the firm, and she had handled most of their conveyancing transactions. Her evidence was that she did not remember the specific occasion. Her evidence was further that she would have attested it properly because her boss, Mr. R, had told her that she was never to attest unless she had seen the person sign. Trial judge initially found that her recollection was faulty and that her attesting signature was false. Blah 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 blah. But we don't care what the trial judge says so much. We more want to look at what was ultimately found in the court, in the higher court. So the question is whether the conduct could be brought home. As I mentioned before, the trial judge found that no fraud because she had not acted dishonestly, nor had Mr. Russo. This was appealed. The most satisfactory definition of fraud is to be found in the New Zealand case, Wahima sawmilling case. The term fraud is not to be used in its most restrictive sense as including mere deceit, nor in its wider sense as including the constructive, equitable fraud of the Court of Chancery. But what Section 42 fraud does mean is dishonesty. This goes back to the Assets Code case, and it includes a willful and conscious disregard and a violation of the rights of other people. The trial judge's conclusion that Rita was not fraudulent was surprising, given AGC, being AGC v. Diaga, the case which what's the word? The case which I don't think is on your reading guide anymore. Gerarda had engaged in known falsity. She was aware that she should not have done what she did. It was no mere oversight on her part, but it was a false statement. But Court of Appeal agreed with the trial judge that she was not guilty of fraud because the critical elements of Section 42 fraud were lacking. There was no dishonesty, moral turpitude, or willful and conscious desire to defeat and disregard another person's rights. The difference from AGC was that the evidence was lacking and that she did not know it had been forged, and there was no evidence regarding her understanding of the conveyancing procedures or the process of registration or the significance of registration. Maybe she was lucky because she was only 3 years of experience, and they argue that because of her lack of experience, she shouldn't necessarily have known. Um, but yes, and then there was question as to whether the bank was otherwise guilty of fraud, and Bat thought that even if Gerada or Gerada and Reichman collectively had been guilty of fraud, there was just too much remoteness going back so far as the Bendigo Bank and the different kind of parties, so ultimately it couldn't be made out. But yeah, that's the Russo case. It kind of just deals with agency, attestation primarily, and then there was an issue with kind of agency and kind of very, very, very extended chains of agency and whether that can be brought home. Anyway, that's it for today. Sorry for it being a bit longer than usual. A lot to get through, a lot of cases. I'm just very I will talk about some of these cases again in some of the coming classes, but I'm wary to post the full case notes as I'm aware that that could be an issue. But yeah, that is the first part of Section 42 fraud for you guys. Hopefully it's being informative as much as it could be, and I will just stop sharing and I will see you guys all next week.